Thank you all for your patience. So just a few thoughts to share. And the first, I would just say how we got here. At the outset, I'll just note that at the time of indictment, we were in this courtroom in the middle of another murder trial, so I was not able to conduct the first appearance for Mr. Floyd. But throughout that week during the trial, we were presented with these consented bond orders, which were negotiated by the parties, and that I signed without a hearing. And Mr. Floyd agreed to abide by the terms of it. And I think it's clear from the case law there is no constitutional right to bail. And a bond can contain special conditions as long as they're reasonable under the circumstances. And often those can curtail or even eliminate a defendant's constitutional rights under the First Amendment, under the Fourth Amendment, such as forbidding contact. We see that quite commonly. And the question becomes, the trial court has to balance the rights of the accused, as well as the public safety interests that are raised by any particular case. But I'll also note that a defendant is generally allowed to publicly criticize the merits of a case, to say that the prosecution doesn't have a case, to challenge the strength of the evidence, to speak his mind. And I don't see anything in this consent bond order that limited general criticism of the state's case. Each of these conditions had components to them, had preconditions, but there was no general limitation of talking about this case. But obviously that criticism not cross a line and ever evolve into witness intimidation. And I think, as the defense was willing to concede here, Mr. Floyd seems very boldly willing to explore exactly where that line lies in this case. And I think the state has made a compelling argument on many of these points. But in categorizing these statements, on the first point of intimidation, we don't see, as we might see in these bond conditions, as they're traditionally understood, someone posting the personal info of a witness or a co-defendant. We don't see someone directly messaging, again, as that's traditionally understood. And we don't see in the wording an explicit indication that something ought to be done about these individuals or that they should be targeted in some way. I read these as seeing more that someone is wanting to defend his case in a very public way. And so on the question of, and especially when it comes to the public officials, I think we've, as Mr. Sterling testified, when it comes to intimidation, they've endured far worse than is presented in this motion. I think it becomes a much closer question when we start talking about whether this is direct or indirect communication. And we're getting into also kind of a question of at what point is someone responsible for the response of others. And I don't know if those are necessarily settled questions under the traditional bond limitations that we used and the phrasing that we used in this case. And ultimately, I think that, first of all, the defense argument that there's no knowledge that these were potential witnesses, that's not an argument that I'm buying. I think that we can't hide behind a veil of ignorance when certain witnesses have testified before the special grand jury or are very much known to be involved in the facts of this case, or just recently pleaded guilty and were known to have a public cooperation provision. I also think that when we're talking about the facts of this case, that is a broadly understood term, and if someone is just denigrating another person who's known to be a witness and talking in reference to their proffer, that's also satisfying that precondition. But when it comes to the question of indirect communication, again, I think it comes down to, while there may, I do think that in several instances here, there has been a technical violation of Mr. Floyd's bond, and that communications he made wound up before the eyes and ears of potential witnesses and co-defendants. But not every violation compels revocation. And so I am stuck on the question of notice, and that the bond conditions as written, in my mind, were not specific enough to account for the nuances of social media. So I think the ultimate result of today's hearing is that it's very clear to me that this bond needs to be modified. And I think it needs to specifically prohibit any public comment concerning Ms. Freeman, concerning her daughter, and concerning other witnesses that need to be included, because even if he's not directly or indirectly communicating with him, however we define that term, I think the public safety interests raised as a result of today's hearing indicate that his actions have a consequence. And because he's under the conditions of this bond order, the court has the ability to curtail and protect that interest. So ultimately what I would be asking for is for a recommendation from the state, but I would also allow the defense to respond of exactly how they would propose adding or modifying these bond conditions. And I will then take those under advisement and enter a modification on the record. And nothing from today's hearing should be seen as curtailing the state's ability to refile such a bond revocation motion immediately upon an additional violation. And I think that it also is very much dependent on the specific facts of the tweets and communications at issue here. And it can't be so broadly defined to cover all other co-defendants. So on the issue of modification, I think that's something that we can revisit and let time to consider, unless there's something the parties would like to address now and want the court to be able to consider specifically what they would like to see as a modification. Or that's something we can follow up, but the court is available and ready to enter that as soon as it's conveyed. Anything, Ms. Willis, that you would like to add?
Obviously, we're very concerned about the safety of Ms. Ruby Freeman. She has clearly endured enough. And this conduct is not just chilling to her, it's chilling to other people who would want to serve in her capacity. So, you know, we respect the ruling of the court, but take exception. This defendant is very well aware of what happens when he tweets about Ms. Freeman. We do not believe it is appropriate for him to make derogatory comments about anyone. He can publicly criticize me all he wants. I don't value his opinion, it doesn't matter. But what he may not do is publicly do things that intimidate witnesses, and so that needs to be clear. He should not be able to tag them so that they are communicated with, or put them in open space so that Ruby Freeman now may have to move again and get another advisement from the FBI. And so if you are, I would ask that before Your Honor leaves here today, that my team be allowed to sit down and that the defendant personally sign off on an agreement stating that he, an initial each clause, so that it can be made more clear that he should not contact and intimidate witnesses in this case.
I don't have any concerns with what you've raised. Mr. Morrison, Mr. Cattrall.
Briefly, Judge, I'm not going to sit down and initial language that I haven't seen, number one, or had time to look at, cogitate, ruminate, pontificate over. I think the appropriate thing for us to do is what you suggested. We'll submit our orders. You take what you think is appropriate and reasonable and enter it that way.
But I think she's stepping back today, and then we can get it worked out, then he can be loose.
Well, I think there's still time to the day. Why don't we see how far we get? I'm not going anywhere. And again, I don't think we're writing a treatise here, but I think there needs to be something more explicit and a little bit more definite. And it can be as all-encompassing as we need to be. And if we need to go back on the record about that, we can. So how about I will check back in with everybody closer to 5, and we'll see where we are. And if we need more time, we can take more time.
Your Honor, does the court have a jury room where we could